People State of Michigan versus Avion Traylor. Both of those matters before the court for sentencing. Will the parties please state their appearances for the record?
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
And good morning, Your Honor. Attorney Kiana Franklin with P73015 on behalf of Ms. Alisha Hollamon, who's standing at the table to my left. Ms. Hollamon, please state your name for the record.
Alisha Hollamon.
All right, thank you, and it's good to see you, Ms. Franulik. And if you want to sit throughout the proceedings, there's no problem with that. Okay.
Thank you.
Well, go ahead.
Good morning, Your Honor, and to your staff. May it please His Most Honorable Court, Mohammed Nasser, P74485, appearing on behalf and with Mr. Avion Traylor, who appears standing to my left. So please state your full name for this Honorable Court.
My name is Avion Traylor.
Okay. And Ms. Johnson?
Good morning, Your Honor. Harshin Johnson on behalf of the Probation Department for docket number 22001978.
Okay. There's been a request to have a new attorney, Mr. Sharp. We had a sidebar discussion. Obviously, I'm not going to adjourn the sentencing. I indicated that he has a motion that I will hear. And if I deny the motion, I will still go forward with sentencing. He indicated, I don't want to put words in your mouth, Mr. Sharp, that you would be prepared to go forward with the sentencing, correct?
Yes, Your Honor. Again, as I indicated during the sidebar, I've reviewed the pre-sentence investigation report. I've not shared it with with my client. So I'll need a few minutes so that Mr. Traylor can obviously be apprised of what the pre-sentence investigation indicates. And then, yes, we'll be ready to proceed if you deny my motion.
Okay, thank you. I will, and you're asking to be excused, Mr. Nasser.
I am, Judge. I've had an opportunity to speak to Mr. Traylor post plea. I've also spoken to him today. I've spoken to the family. They have indicated that they would, pursuant to the stipulated order, have Mr. Sharp proceed forward. Certainly, I wish nothing but the best for Mr. Traylor. If that is what they wish, then I would respectfully ask this court to withdraw and allow fine attorney Mr. Sharp to proceed.
Okay. Your motion to withdraw is granted, and the people don't need to be heard on this, do they?
I don't believe so, Judge.
Okay, thank you. Thank you, Mr. Nasser. Okay, there's a motion to withdraw a plea. Go ahead.
Yes, Your Honor. I don't think I've placed my
I'm sorry.
on the.
I'm sorry. I apologize.
No problem. Michael Sharp appearing on behalf of the defendant, Avion Traylor, P37633.
All right, go ahead, sir.
Yes. I filed a motion to withdraw my client's plea. It was filed on I think over the weekend, probably accepted on Monday. It's a motion with an attached affidavit. I've shared the motion with my client. The people have responded and they opposed the motion. I've shared with my client the people's response to my motion. I think it was at the jail yesterday. First off, Judge, the event that causes my client to be here is clearly a tragic one. I think by anybody's estimation, including my client's, he agrees with that. I don't know that I need to read every page with respect to my motion, but I've filed it. I'm sure you've read it. People certainly have because they've responded to it. I'll indicate this. While the people are correct, I was not the counsel of record at the preliminary examination, at the plea. However, I know how to review a record. And the record indicates, and my client shared with me, that when he made his plea, there was some, to put it politely, hesitation in entering the plea. I know this court, as it always does, I know this court very well. questioned my client with respect to his role in this particular matter, and initially he denied any guilt. After, I guess, a continuance, he obviously changed his mind and he admitted guilt. Now, just so that the record is clear, I think there may have been 2 or 3 typos with respect to the type of plea my client made. I know he didn't plead no contest. It's a typo. I used the word guilt all over the place, so nobody should be confused about that. The bottom line is that he indicated initially that he was innocent, and he maintains that in his affidavit as well. I've cited the court rule. I think the people, I would agree with the people that there may be some inconvenience to them as far as expert witnesses and those sorts of things, restarting the case per se, but inconvenience and prejudice are 2 completely different things. As I indicated in my motion, or at least my client shares with me, that over a 2-year period, he did see his lawyers briefly, and that's putting it kindly, the way it was put to me after court hearings, that sort of thing, in this building on the other side of the wall, never in the Wayne County Jail, never discussed what trial strategy would be, never discussed what a trial even was. And the day that he actually was to make his plea, the jury was waiting. And he was told, he says, by his lawyer, that he had no chance to win the trial. That's what he says. And so that's where the whole hesitation came about. And the bottom line is that he indicated to me that he felt pressured, and that's why he changed his mind. So I've cited the court rule. I would respectfully ask that you grant my motion. If the court has any questions of me, I would be more than happy to try to assist the court.
Thank you, Mr. Sherman. Anything else?
Yes, Judge. As defense has mentioned, I did file a response to their motion to withdraw the guilty plea. I did file that upon receipt of their motion, I believe, earlier this week. Again, what I've heard a lot of is the word hesitation. And what that is not in the interest of justice. A hesitation or a dissatisfaction with a counsel registering some doubt about accuracy is very clearly, according to the case law, not sufficient to justify a withdrawal of the plea. It's the defendant's burden of establishing that it's in the interest of justice to withdraw the plea. A baseless claim of actual innocence here is not enough, Judge, and we know that based on the facts that have been within evidence within this court's review. And what we have here is not just a day of plea, Judge. It may seem like that. However, what actually happened was that the Friday before the Labor Day weekend is when we reached the plea deal, and that form was signed on that Friday. Attorney Nasser came to my office. We met downstairs. My office is connected to the building. I brought him the plea form. He went to the jail. He said he was at the jail visiting with Mr. Traylor. He went back to the jail. He went through the form, had him sign it. He signed it that Friday, Judge. He knew that what this plea was going to take. And then we had that Labor Day weekend. We come back on September 2nd. It's not as if he was given a plea form that day, had to rush through it, had to do all these things. That's not the case here. so to make it seem like, oh, he changed his mind or he had some hesitation, that's not in the interest of justice. Which again is the defendant's burden to prove. I really don't want to hash through my entire motion, Judge. I know you've read it.
I've read both parties' motions.
So
I was here at the plea,
yeah,
and I'm prepared to rule, but I want to make sure everybody that wants to make an argument, they can make their argument. I did read the motions. It's thorough on both sides, what both positions are. Anything else?
no, Judge. That's the people's basis. Everything that's contained within our motion response. There's no legal basis to withdraw this guilty plea, Judge.
Okay, thank you.
Just
Anything else?
brief rebuttal. I had used the word hesitation, and the people were correct in repeating what I used. I also said he was innocent. They left that part out. And, other than that, we're ready for the court to proceed.
All right, thank you. Thank you, everyone. The issue here is, first of all, I respect both parties' arguments. All of the three attorneys, Mr. Sharp, Mr. Nasser, Ms. Ripley, have been before this court. They are all, in my view, very, very good, outstanding attorneys. And so the characterization of Mr. Nasser, I will say, does not indicate my experience with him in being a strong advocate for his clients. That's not really the issue here. The issue here is whether or not, pursuant to MCR 6.310, Mr. Traylor should be able to withdraw his plea. And the evidence, quite frankly, in this case is overwhelming. And there can be a claim of maintaining his innocence. He certainly, while under oath, didn't maintain his innocence. He made a factual basis to torturing Deshawn. And I'll get to that in a second. But there was evidence. There was evidence including statements by the co-defendant that would inculpate him in this crime. His own statements that, at the very least, based on pretrial motions, were false exculpatory statements. The case, and I'll get to this more in sentencing, but look, there's an audio and video. There's a video of a little boy who was screaming for his life that the defendant consistently went down, came back up, went down, came back up. The corroborating evidence in this case strongly shows that the defendant, Mr. Traylor, was the one who committed this crime. Now, specifically, with regards to MCR 6.310, I placed Mr. Taylor under oath, and there may have been a hesitation. Yes, we were ready to go for trial. For 2 years, we've been almost 2 years. This court would have been ready to go for trial. There was an adjournment by both sides. This is an old case, and now there's a claim. And I said we are going to do the trial. And it was brought to the court's attention that with the hesitation after that, he does want to admit guilt. He doesn't want to have a jury trial. So before we brought the jury in, I swore him in under oath. I asked him if he understood that if he pled guilty, he would be giving up his right to a trial by jury, be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that he is guilty, to have the witnesses against him appear at trial, to question the witnesses against him, to have the court order any witnesses that he has for his defense to appear at the trial, to not have his silence used against him, and if he wants to testify at trial, he can testify. He indicated under oath that he understood his constitutional rights. I asked him, is he pleading guilty because he is guilty to what he's pleading guilty to? He said, under oath, yes. I asked him if there were any threats. Is he pleading or is he pleading guilty because of any promises or threats that were not disclosed to me? Under oath, he said no. I asked him if there was any promises made to him. Under oath, he said no, other than what was placed on the record in the plea agreement. I asked him if he was threatened by anyone or forced to plead guilty? He said no. And he indicated it was his own free choice to plead guilty. And I asked him directly if he beat and tortured Deshawn, and whether or not Deshawn died as a result of what he did. And he said under oath, yes. So I am not going to allow him to withdraw his plea. The objection will be noted for the record. We'll go off the record and let us know. We'll have to logistically figure out how to do this, but let us know when you're ready, Mr. Sharp, okay?
Okay, thank you, Judge.
How long do you think you need?
15 minutes.
15 minutes? Jackson? I suppose you do out of custody. You can stay right there if you're fine with that.
Yeah, I'm fine.
All right, we will just do some out of custody cases if the attorneys on Ms. Hollamon and Mr. Traylor will tight.
Yeah, I'm not for a minute. I need to move around.
Yeah, do whatever you need to do. Actually, are you ready on your other case?
I don't believe it is just Avion, Your Honor. And I did contact him. I do have the absconder report, so,
Okay.
but the co-defendant, I don't see co-defendant's counsel.
Well, I was
Miss
thinking
Michelle.
separately.
Oh, Miss Michelle, you took over Elizabeth? Yeah. Should I resend it to you?
What we can do, Max, you tell us what to do, okay?
Okay.
You maybe do that one as well.
So it's Jenkins Jackson first.
Okay, along with,
It's
Deshawn, are you
it's
ready?
it's in custody. So
Okay, why don't we'll just do them separately if that's all right.
we're gonna make sure.
That's not by me.
Yeah, absolutely. And you can put it back up if you want. Don't worry about it.
Parties on
I
Jenkins.
I was gonna say, I know it goes without saying, you're not gonna video the other things.
No.
I knew you wouldn't.
Thank you, sir.
Okay, well, I guess. All right, next, I'm gonna call the case. You're fine, I'll call the case. This is case 25-003424, People of the State of Michigan versus Devon Jenkins Jackson. Appearances, please.
Good morning, Your Honor. May I please this honorable court, Gabrielle Pruitt on behalf of the people, P87218. And good morning, Your Honor, Attorney Deshawn with P73015 on behalf of Mr. Jenkins Jackson. Your Honor, he is not present in the courtroom, and I have not heard from him this morning.
Okay. Well, he knew about this date.
Yes, Your Honor. He was in court in person on the day that this was set. I was also provided the absconder report from your JA this morning as well. So at this time, unfortunately, I have no response for his whereabouts. I did attempt to contact him this morning also.
Okay, thank you. KPS will be issued. I will be working. He'll be remanded for that on arrest. Now, I do want to, and Ms. Michon is here in the courtroom as well. Ms. Michon, if you don't mind, can you come forward and just on a scheduling matter?
Defendant 1, People State of Michigan versus Alisha Hollamon. That matters before the court for sentencing and calling cases 23006212, Defendant 2, and 22001978, People State of Michigan versus Avion Traylor. Both matters before the court for sentencing. Will the parties please state their appearances for the record?
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
And good morning, Your Honor. Attorney Ken Frank with P73015 on behalf of Ms. Alisha Hollamon, who is standing to my left. Ms. Hollamon, please state your name for the record again. Alisha Hollamon.
All right, thank you, everyone. And all parties agree that we can do these two cases simultaneous. There's been a request to do that, and there'll be objections. Is that correct?
You probably want me to put my appearance on the record, Judge?
Oh, I'm sorry, Mr. Sherman. I apologize. Go ahead.
I'm going to take it personal, Judge. No, man. May it please the court, Michael Sharp appearing on behalf of the defendant, P37633, and state your name for the record, sir.
My name is Avion Traylor.
Okay, thank you, and I apologize. All parties agree that we can do these sentences simultaneous?
Yes.
Yes, Judge.
Yes, Your Honor.
Okay, thank you. I'll start with Mr. Traylor as the pre-sentence report. Mr. Sharp, any additions, corrections, or deletions?
Just one correction. I think it was on page 1 of the evaluation and plan. I think it's 4th paragraph, 2nd line. It indicates that my client had a 10th grade education. Actually, should be 8th grade education. Other than that, everything else seems accurate.
Okay. And it says that in other places in the report as well. It says 8th grade. Thank you.
You're welcome.
With regards to the guidelines for Mr. Traylor, any additions, corrections, or deletions from either?
No, I think they're properly scored, Judge.
The people do have some corrections, Judge. It does ultimately lower the total.
Okay.
But OB1, I believe should be properly scored at 10.
Any objection?
No, Your Honor.
10? Okay.
OB2 should be scored at 1.
Any objection?
None.
Okay.
And OB6 should actually be 25.
Any objection?
No.
Okay.
That brings the total OBs to 166. The level stays the same and the range stays the same.
Okay. And Mr. Sharp, you agree with that?
Yes, Your Honor.
Thank you, sir. And
Judge, I did have one other correction, and this is for Mr. Traylor and Ms. Hollamons. Their jail time should be
one more day?
two more days.
Okay. Oh yeah, that's right. That's right. And obviously, there's no objection, correct?
None.
No, Your Honor.
Okay, that'll be 710 for Mr. Traylor and for Ms. Hollamon.
It'll be 711. They have her at 709.
Okay.
Yeah, she was arrested the day before, so.
711 for Ms. Hollamon. All right. With regards to the report of Mr. Traylor, Ms. Ripley, do you have any additions, corrections, or deletions?
None, Judge.
No, Judge, not to the body of the report.
Okay, with regards to Ms. Hollamon, Ms. Fernulik, do you have any additions, corrections, or deletions to the body of the report?
No, Your Honor. I had opportunity to go over it with Ms. Hollamon. There are no factual corrections, deletions, or additions that need to be made outside of the jail credit that has already been addressed by the court.
Okay, thank you. And with regards, Ms. Ripley, to the body of the report of Ms. Hollamon, any corrections, additions, or deletions?
No, Judge.
Okay, and the guidelines for Ms. Hollamon are 162 to 270. Any additions or corrections to the guidelines, Ms. Ripley?
No, Judge.
Ms. Fernulik?
No, Your Honor. Those are accurate, and I would also state that the sentence and plea offer actually falls below the guideline maximum.
Okay. All right.
Yes, Judge. We do have a family member who would like to speak. Where would you like them to go?
Usually it's the first row of the jury box. I don't have any problem with that continuing. And who is that individual?
It is aunt of Deshawn, Miss Crystal Hollamon.
All right, thank you. Miss Crystal Hollamon, if you want to come forward. And you can have a seat. That's fine if that's okay with you, or you can sit in the second chair, whatever you feel comfortable. And you can stand or you can sit. It's up to you. Okay. Dave, can you state your name for the record, please?
Yes. My name is Crystal Hollamon, the aunt of Deshawn Dwayne Williams.
Okay, thank you for being here. This is your opportunity to speak how it's affected you, to speak about Deshawn, and you can direct your comments to me, okay?
Okay.
Thank you so much for being here. Take your time.
Okay. Words cannot explain the pain, grief, anxiety, heartbreak you have caused my family. This is by far the worst thing we had to endure as a family. Reach out countless times to wrap our minds around what kind of human beings could commit such heinous crime on a 7-year-old innocent little boy full of life, laughter, love, and joy. Deshawn Dwayne Williams did not deserve to be treated so badly. Honestly, there is no words to explain in detail the sick, disgusting, demonic, ritual-like crime you committed. There is no logical explanation for your behavior other than your pure evil. This kind of wicked behavior just did not happen overnight, or even the few years you was dating my sister Alisha. This kind of evil was embedded in you at a young age. It all starts at home. It is clear that your mom and father failed you. You gave red flags early on. They ignored them. Abused child, rejected child, unloved child, SSA child, abandoned child. They did it to you, so you did it to him. You decided not to heal, but to kill an innocent child, not a grown man that could defend himself, but a 7-year-old child. What a coward. The harsh reality is that your mom gave birth to a demon. You took the plea deal, which tells me that you are guilty. You acknowledge that you are. And I can say what I think you deserve. But then none of that matters, because the vengeance is the Lord's. And I ask that God have mercy on your soul.
Thank you, Ms. Holland. Thank you. All right, Ms. Ripley. Anything else from the people?
Judge, I would just like to say that this case has been along for a while, and it is truly one of the most egregious cases that I have seen in my career. It's even one of the most egregious cases that our medical examiner has seen, as she has stated to me multiple times. The only good thing I can say about this is that I'm glad that the world and Deshawn's family did not have to see all of the photos, all of the videos of this. So I'm glad that the family was spared from having to have to see Deshawn like that. I think that the agreements that we came to are more than fair in this case, Judge. And I ask that you adopt them.
Thank you. Anything on behalf of the probation department, Ms. Johnson?
Your Honor, the probation department would ask that you close out docket number 22 12001978 without improvement.
Okay, thank you. Mr. Sharp, go ahead, and Mr. Traylor, you can come forward, sir.
Thank you, Judge. Well, obviously, everything that Ms. Hollamon said is accurate, and frankly, a parent's, aunts, uncles, grandparents' worst nightmare. This is generally the time, Judge, where my client apologizes for what he did. And this by no means is any disrespect to the young man's family or to this court. You just heard me argue a motion, and quite frankly, depending upon what my client's family has to say, once we discuss the matter, there may be legal issues that continue or not. So I don't think I'll try to be a good lawyer. And so if it appears as if my client was not apologetic, was not sympathetic, that's not the case at all, and I'll have to take the blame for that. Otherwise, as I've indicated, everything seems accurate. You've read the pre-sentence investigation report. There's really no reason to belabor a point. I'll apologize. This is something that never should have happened. And hopefully nobody in that family or anybody else's family will have to go through it again. Thanks for hearing me out, Judge.
Thank you, Mr. Sharp. Mr. Traylor, is there anything you'd like to say?
No, sir.
Anything on behalf of Ms. Hollamon, Ms. Vernulik? And Ms. Hollamon, if
Yes,
you can stand up, Ms. Hollamon, but obviously Ms. Vernulik, you can stay there.
I'm going to stand on my client.
Okay, thank you. I just want to make sure that you're comfortable.
Your Honor.
Do you want to stand there?
I'll stand.
Okay.
Your Honor, from the moment I met Ms. Hollamon, she has presented herself to me as a woman in grief, fear, disbelief, and also her own guilt. Her failure to protect her child, which is one of the things that is most natural to most, is something that she is living with daily and suffers with herself. The fact that she did not stop what happened to her child is something that she expresses remorse and guilt upon every time that I've had the opportunity. And I've met with Ms. Hollamon on a number of occasions. Ms. Hollamon has, at every single moment, expressed remorse for what happened to her son, and also acceptance of the fact that she allowed her fear from what was also being done to her fail to protect her child. She does not stand here as someone who is asking the court to take any excuses from her. She does not stand here to make any excuses on behalf of what happened. But she was also someone that was ready to finally stand up to her abuser for her child, giving him the last bit of rest that she believed that she could, which was to testify for him. Now, she does not say that to mitigate or lessen her failure to protect him, but as far as a way of trying to help her son get the justice that he deserved, and that was the step that she was going to take. And even in doing that and preparing for that, she was fearful to even testify, but she was going to do it, even knowing that he's in custody as well. She has been fearful. Your Honor, she entered and has accepted this plea offer because she understands that as her role as a parent, she failed to protect Deshawn. And that is something that she's living with daily and will continue to live with for the rest of her life. We do ask the court to accept the plea agreement and offer that was made in this case and sentence her to the offer that was accepted. It is within the guideline range. It does not exceed the guidelines, even though it is near the higher end. The guideline max was 22 years. The plea offer in this case is 20, and we ask that the court accept that along with the 711 days of jail credit.
Thank you, Ms. Vernulik. Ms. Hollamon, is there anything you'd like to say? Okay, thank you. I will indicate to both defendants that you may file an application for leave to appeal your conviction and sentence. If you cannot afford to hire an attorney, the court will appoint an attorney and furnish the attorney with the transcripts and file necessary for you to handle your appeal. Your request for an attorney must be made within 42 days. With regards to credit time, as stated, Mr. Traylor is going to have 710 days credit for the time that he has served in the Wayne County Jail. Ms. Hollamon is going to have 711 days credit for the time that she has served in the Wayne County Jail. With regards to costs and fees, Mr. Traylor will have $1,300 in court costs, $68 in state costs, $130 in Crown Victims Assessment fee. There will be no verbal, electronic, written, or electronic or physical contact with Alisha Hollamon or the family of Deshawn Williams in any way. With regards to Ms. Hollamon, there will be $400 in attorney fees, $68 in state costs, $1,300 in court costs, and $130 in a crime victims assessment. With regards to Mr. Traylor's probation case, this is case 22-001978. He will be closed out of probation with credit for 710 days served, and it will be without improvement. HIDA will be revoked on that case as well. The case has been a very difficult case for everybody involved. Deshawn Williams is 7 years old. He died of blunt force trauma to his head and his pelvis. Multiple blunt force blows to his head and to his pelvis. Burns were on his leg. Hot water was poured over him. He was tortured. Now, with regards to Ms. Hollamon, she facilitated this and then lied to police about what happened. Mr. Traylor tried to first blame it on somebody else and lied to police as well. This is a horrible case for many reasons, but I actually was able to hear a lot of the evidence because of pretrial motions. You can hear Deshawn crying for his life on the recording. Neither of these defendants are victims in any way with regards to this case as far as this court's concerned. With regards to Ms. Hollamon, and I do have a lot of respect for all of the attorneys, Ms. Vernulik, Mr. Sharp, Ms. Ripley, but for her actions, Deshawn would never have been tortured in the way that he was tortured. This is the worst case that I've seen in my time as a judge, which is 9 years now. Quite frankly, I've been involved in criminal law for 18 years. This is the worst case that I've seen. And sometimes, people that work in this courthouse, whether it be defense attorneys or prosecutors, judges, deputies, I always worry. I hope never to be desensitized to any violence because we see it on a daily basis. We hope never to be that way. And I'm sure everyone involved in this case will remember this for the rest of their life. And I'm glad to say that did not happen to me. Everybody was moved by the horror that we saw on that video and that audio. It was one of the worst things, probably the worst thing I've ever seen, I've ever heard. And what I can indicate as well, something that I don't always, I almost never say this at a time of sentencing. But based on what I have said so far, based on how horrible of a case this was, based on what Deshawn, a 7-year-old innocent boy, had to suffer, I hope that Ms. Hollamon, and I hope the parole board hears this and looks back on this 20 years from now for Ms. Hollamon and 28 years from now with regards to Mr. Traylor. Mr. Traylor deserves to spend 60 years in prison. Ms. Hollamon deserves to spend 40 years in prison for what they did to Deshawn. I will adopt the sentence agreement in this case, and with regards to Ms. Hollamon, sentence her to 20 to 40 years in the Michigan Department of Corrections, and with regards to Mr. Traylor, sentence him to 40 to 60 years in the Michigan Department of Corrections. Thank you, everyone.
What you sentence him to what?
40 to 60 years. I'm sorry, 28 to 60 years in the Michigan Department of Corrections. I apologize. I misread something.
Okay.
Thank
All
you.
right, I just wanted to make sure. Thank you, Judge.
Thank you, and I'm sorry, Mr. Sharp. I was looking at
No
the,
problem. No
You can
problem.
probably figure out I was looking at the Mexican. Sorry about that.
No, it's okay. I just want to make sure
I got that right, though. Yeah.